Yes.
Okay. All right, I can hear you too. All right, this is 240P01688. This is the People versus Lita Bay. Officer Milosh, would you please state your name?
Yes, ma'am. First name Nathan, Nathan. Last Milosh, Mloche.
And Miss Bay, would you please state your name?
I'm the executrix of the estate for Lita Bay.
All right, we're here today for, looks like a ticket that was issued back on July 14th of 2024. All right, Officer Milosh, it's the government's burden. So you'll go first. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right. So what can you tell me about the ticket that was issued on July 14th, 2024 to Lita Bay at Coolidge and Pearson in the city of Oak Park?
Yes, ma'am. The citation was issued due to Miss Bay disobeying the red light at actually Coolidge and North End. Once we got through that intersection, Miss Bay did come to a stop at Coolidge and Pearson. And then once that light cycled through, I initiated a traffic stop just north of Pearson, just south of Albany on Coolidge there at about approximately 10:45 p.m. At that time, I went up to speak to Miss Bay. Initially, she refused. She did provide a license and eventually started speaking with me. Returned to my patrol vehicle, at which time she exited her vehicle, went to the rear of her vehicle, opened up her trunk. Went up to speak with her and escort her back to her seat in her car, at which point she started resisting. So my fellow officer and I took her to the front of my car, spoke with her, initially handcuffed for officer safety. We released her without charging her for the misdemeanor for resisting and obstructing, and we just went with the disobey red light. And actually at minute 158 of my body cam, Miss Bay does admit to the infraction of disobeying the red light, stating she had to use the bathroom.
When you say resisting, what do you mean?
So initially we went up to her, asked her to step away from the trunk. Obviously we didn't know what was in there. She then began to retreat from officers. We then grabbed her arm to help escort her to her vehicle, at which point she tensed up, pulled away, and started screaming at us.
What do you mean by screaming? What did she say?
Am I able to reference my report I have here?
You may.
Thank you. All I have here is that she kept screaming, "Help me." Initially, when she was in her vehicle, she stated she didn't want to speak with us and that we were forcing her to say things against her will, and that she was nervous because we had our sidearms and we were near her children. Once she was resisting, all I have noted here is that she kept screaming, "Help me." And that's all I've got in terms of that. I don't have access to my body camera footage at this time.
Why is that?
This is virtual court, so I don't have access to evidence.com.
All right. And Miss Bay?
I'm the executrix for the I'm the executrix for the trust for Lita Bay.
All right, Miss Bay, raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give is the truth and nothing but the truth under the penalties of perjury?
I do.
All right. What can you tell me about the ticket that was issued to you?
Your Honor, I actually put in paperwork and asked for discovery, and I was advised that I shouldn't testify until I get my discovery packet.
So this isn't a criminal case. It's a civil infraction. You were free to order under the Freedom of Information Act any information regarding this case prior to the hearing. So it's not like a criminal case. It's a different standard. It's just a preponderance. It's not beyond a reasonable doubt. But you most certainly would have had access to that if you just FOIA'd the report or the body cam in this case. But we are having the hearing today, and you're free to give me your side of the story if you so choose.
On the day in question, I went through a red light. I had to use the bathroom, like really desperately. I had three teenagers in a car with me. And when the officer officers approached my vehicle, touching their sidearms. My daughter had the identification, and I explained to them that this was a trust situation, and they didn't care. She was terrified, and she ended up taking out my ID because she did not want us to get killed or beat up or anything. Because things have happened to family members. I didn't want to get tased. She didn't want us to get tased or beaten or killed. So she ended up taking out my ID because I did not have to identify. It was not a situation for identifying, but we were forced to because of the guns and stuff. And my children were terrified. My son's girlfriend was in the car. She was terrified. I told him it was a trust situation, and I told him I had to use the restroom. And because he said something about me going through the red light, which there was no traffic. The traffic light is to direct traffic. There was no traffic. I really had to go, and I was really trying to get to the destination because I have a medical condition that's life-threatening right now. So I explained it was a trust, and they went to the car, and I got out to get tissue out my car, which I have a receipt and a picture that I did have tissue in my car. I was going to use the bathroom on the side of a house or wherever because I was not going to expose myself to waste matter with my blood condition. They came up to me, and I was like, ma'am, what are you doing? They all rushed towards me. They all grabbed me. Then all of a sudden, somebody had their hands between my legs, brisket touching me, my breasts, searching me. They pushed me up against the car. They put cuffs on me in front of my children. They put me in the back of the car. I was screaming for help. They went up to the car, and they were taunting my son in front of his girlfriend and his little sister who looks up to him. Like, I said, I just had to use the bathroom. I asked them nicely. I said, can you please just sit me on the ground? I do not want to waste inside of your car. I wasted myself in my car once I got back in my car after they put me in the back of the car. So that's what happened on that day. And I asked the officers, how would you want your mother handled? I'm an older woman. And he did this in front of my children. I went to the temple earlier that day, in the Hindu temple, and did sacred rituals. Wasn't nobody supposed to be touching me. And somebody just came up to me and was touching between my legs and my breast. And I don't know where they came from, and they were all surrounding me.
Anything else you want to say, Ms. Bay?
I was screaming for help because I was terrified for my life. I was not guilty of anything, but needing to use the bathroom and not wanting to soil myself. I just wanted to get to my destination, which was off of Oneida and 9 Mile, which literally 2 minutes away. I did not make it.
Okay. All right, the court has heard the testimony from Officer Milosh and from Ms. Bay in this case. The standard is a preponderance of evidence. Mr. Milosh testified that he saw Ms. Bay run the red light at Coolidge and North End. Ms. Bay acknowledged running the red light in question in this case. The people's burden is satisfied beyond a preponderance of the evidence in this case. I'm finding Ms. Bay responsible for running a red light. The fine is going to be $165. You'll have till October 1st to pay it. I will send that to the Novara address where we sent the other notices, so you'll get the paperwork in the mail. You're all set.
Excuse me, Your Honor. So what I'm asking you is, I have a question. You're telling me, is the court telling me that trust situations are not seen as trust because this is a trust matter? This is not
Right,
what
so
you
Ms.
think
Bay,
it is.
there's no trust situation recognized by the court. You are responsible. Make sure you pay the fine back.
25 CR 250. Good
Yes, Your Honor.
afternoon, Ms. Leslie. Ms. Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though Then count 4, same date and location, failure to register vehicle and unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an
Excuse me.
attorney. Pardon me?
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 and the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds. And
Court overrules the motion for dismissal of the case.
Court
overrules dismissal of the
prejudice
case.
And
the court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court
I
sets your next
object. You
appearance
called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias. And
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney
No, Your Honor.
and Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognized in Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predeposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a shovel search of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridiem, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
And Mr. Sweeney, that's the last case I show on the first appearance docket.
Thank you, Your Honor.
Have a good day.
I think that's Mr. Dingman. Is that Mr. Dingman?
No, yes.
That's why.
I'm sorry, I thought you said McCreary.
Yeah, no, I'm calling Mr. Dingman. So can you wait for the
Yes,
rest?
I can wait. I thought you were calling McCreary, that's why I was
No.
going to take the opportunity.
All right, we're on the record in the matter of the City of Wyandotte versus Stephen Dingman, 191445 and 241519 A and B. And counsel, your appearance, please.
Your Honor, John Goldblatt, P 30758, on behalf of Mr. Dingman on both matters. I want to indicate to the court, I did provide him, or he was provided with a copy of his constitutional rights. However, he refused to sign it. I did go over those rights with him.
Okay. Who? Mr. Dingman, your name for the record, please.
Stephen Ray Dingman, private trustee.
Okay, who's Keith Hood?
Oh, that's the wrong one. They gave me. I apologize for that, how this came back. They gave me one. I was talking to who I thought was Mr. Dingman, and Mr. Keith Hood said, I am. They found him after there too, so.
Okay, I don't know what a private trustee is, but. Okay. All right, well, today's the date scheduled, well, not scheduled, but Mr. Dingman is in custody. There was a warrant issued for his arrest because he failed to appear for an arraignment pretrial a number of times on the 2019 matter. And then he had a new matter that was scheduled for arraignment pretrial next week, but since he's in custody, we're doing that now.
That is correct, Your Honor.
As to the arraignment, counsel.
As to the arraignment on the 241519 case, Your Honor? That's the one that's the arraignment.
We're arraigning him on both.
Oh, he did not appear for arraignment. Okay.
The 24 matter is scheduled for next week.
Correct.
But since he's in custody, it was moved to today, so we're doing an arraignment only on that.
That I understand, Your Honor.
Yeah.
And he
So
hasn't
we're
been
doing an arraignment only on both.
arraigned On the 19
No.
case, okay. As to both matters, Your Honor, he would stand mute to the charges, waive a formal reading of those charges, and ask that a plea of not guilty be entered.
The court will waive the formal reading, enter a plea of not guilty on both of these matters. And as to the pretrial date, Ally?
2/5 at 9:45.
All right. We are going to set this matter for February 5th at 9:45 a.m. And I think you're here anyway that day, counsel.
Yes,
I mean, I know
sir.
that you don't necessarily have to follow it, but since you're doing the arraignment, maybe you can, I don't know.
Fine, I am here next weekend. I mean, next, right.
All right, and as to bond.
Your Honor, Mr. Dingman is presently unemployed, though he is employed through what is known as Instacart. That's where
Right.
I'm not familiar with it, but it's similar to DoorDash, things like that. However, he's tried DoorDash, but because of his, I guess he's not eligible under their standards because of a prior driving while impaired or alcohol-related offense. Your Honor, he is he just lost his father last October, November. He is trying to get the house and all of his things in order.
My parents both died, everything's in probate. I got no money, I got no job, I'm a man of Christ, I do nothing but stay at home. I just got the Instacart gig, I'm trying to get back on my feet. I know that I didn't come to court for numerous reasons because the last 2 years I was taking care of my elderly parents. And finally, when I was about to get everything taken care of, the night before my dad passed away in his sleep. So now I'm stuck with the house, frozen bank accounts, all kinds of bills. I have no other family. I'm trying, and I understand that I got this thing looming over me, but I'm just trying to get everything taken care of and getting back to order. I still got to get my dad cremated, and the funeral home's mad at me because he's been there since November 27th. I don't leave the house. I don't do anything wrong. The matter about the larceny. I'm just trying to let you guys know that the reason that I was given this ticket was because I didn't know my new address. So the cop, because I had.
It has nothing to do with it, sir. That's not.
He gave me that ticket saying I lied to him and I didn't know my address. That is, if I don't know my address, that's not a lie.
Your Honor, he's talking about the fraudulent schemes.
Yeah. Okay, well, let me just say this, sir. How long were you taking care of your parents?
For 3 years, they're elderly. My mom was 72 and my dad was 83.
Okay, well.
His mother died approximately a year and a half ago, and his father died just before Thanksgiving this year.
Okay. Okay.
And then my dog died 2 weeks or a week after my dad died.
Sir, there are many people that take care of their parents, elderly or not, that still take care of their responsibilities. All right, taking care of your parents does not negate you from taking care of the balance of your responsibilities. You have a matter pending for almost 6 years now. 6 years.
I tried to turn myself in during COVID, but the lockdowns and everything, and I walked up to the door and we can't let you in. Okay.
Sir,
was denied entry.
Stop. That has been something that has not even been a thing for a while now. And our court's been open and we've never stopped our dockets. So.
Yeah, but I didn't have any money to come up here to do that.
Don't even try that, sir. Don't even go there. Because then you were scheduled on September 12th and you walked out. And then we issued a warrant November 1st. And that was 23. Stop interrupting me. And that was in 23. Then you contacted the court in May of 24. We set it for July 31st of 24. You showed up to court in shorts. You said you were homeless. It was rescheduled to September 25th. September 25th, you failed to appear and the court issued a warrant in October 10th. And what have you done since October 10th to set up your court date What have you done, sir, since that time?
Grieve.
Okay.
Grieve.
And so,
loss of my-
while I can understand your grieving for the loss of your father, right, but you still have responsibilities.
Yeah, I get that, but I figured I'd grieve first and then take care of things after the fact. That's why I just started doing Instacart so I could get to taking care of all this stuff. I literally got 3 things done and then I just started to make some money and then I got pulled over. And now all I want to do is just get back to it so that I can get all this stuff taken care of. I got no intentions on doing anything bad or anything. I don't use hard drugs. I don't drink anymore. I turned my life around on July 26th of 2022. It's when I became a man of God and became a trustee. And ever since then, I've been
a trustee as a man of God. What does that mean, sir?
through the United States Internal Revenue Service and the federal government. I applied to trustee status with them and they granted it to me. That's through the United States federal government. Would you like my EIN number?
No. That's part of the problem here. United States government, IRS is granting people that status. That probably has to, anyway. Okay, well, here's what the court's going to do, sir. The court, based upon your previous failure to appear, the fact that you had, I haven't, other than a couple of times that you set up court dates and you still, you don't stay at court or you don't show up, the court doesn't have any confidence that you're going to appear in court.
Your Honor.
Further, while you've been out, while there's been a warrant out for your arrest, you also are now charged with larceny as well. So the court's going to order a $2,500 10% bond in each of these cases.
Okay, Your Honor.
And then the 241519, that's on count B. And in the event you post bond, you're not to be released without a GPS tethered to the Wayne County Jail.
So, what is my bond today?
$250 on each case.
So that's $500 total.
And the GPS tether through the Wayne County Jail.
And no house arrest. And apply,
Hey, I'm sorry. I
submit 20 job applications per week.
how many?
A minimum of 20 job applications per week.
Yeah, I've already filled out over 100. Did you say that I gotta be under house arrest, right? Nah.
Not under house arrest.
Not under house arrest.
Oh, okay.
And you're not to have any contact with Cody Buttram. That's phone contact, text message, email, social media, third party, anything of the like. You also are not to go to his home.
I don't even know who Cody, whoever it is.
And then you'll have no problems not going there.
Correct.
I'm not trying to interrupt. I'm just saying I don't even know who Cody, whatever this guy's name is.
Okay. Well, all right. All right, we'll see you back on February 5th. Thank you.
Thank you, Aaron.